In our last video, we looked at a number of notable employment law decisions that were released last year. Here are a few more from 2013 that employers should be aware of. In June 2013, a newsworthy case came down from the Supreme Court of Canada dealing with the Communications, Energy and Paper Workers Union of Canada Local 30 versus Irving Pulp and Paper in New Brunswick. Now, this case was an example of some back and forth court decisions regarding drug and alcohol testing, which has been a contentious issue across Canada. Ultimately, the Supreme Court ruled mandatory alcohol testing was unreasonable. Now, the case started with Irving Pulp and Paper unilaterally adopting a policy of random breathalyzer testing for 10% of employees in safety-sensitive positions. The union said this was a breach of employee privacy, and an arbitrator found that 8 incidents over 15 years didn't demonstrate a problem, and a proof of a problem was needed to justify such testing. Now, this decision was overturned by the New Brunswick Court of Queen's Bench and the New Brunswick Court of Appeal. However, the Supreme Court of Canada restored the original arbitrator's decision that random alcohol testing in the workplace was unreasonable. An interesting case that was released in July of 2013 dealt with the Ontario Ministry of Community Safety and Correctional Services and OPSEU. It was a grievance settlement board decision that dealt with an Ottawa Carleton Detention Centre correctional officer who suffered discrimination, harassment, and a poisoned workplace. And it was found that the employer failed to accommodate the employee when he became ill as a result of the harassment and discrimination. The employee developed anxiety and deep depression and was also suicidal. It was found that the employee suffered humiliation, victimization, loss of self-respect, and became distrustful of people. And the employer delayed in investigating his complaints, making matters worse and breaching its duty to investigate. Now, as a result of this whole situation, the employee was not able to work again in a correctional institution. So the board awarded the employee 4 years of lost wages, $45,000 in compensatory damages for discrimination and harassment, and $53,000 for failure to accommodate over 4 years. Now, this case was notable because at the time it was the largest amount of human rights damages awarded in Ontario for egregious harm done to an employee by the conduct of an employer. Now, a case that's been in the news for the last few years is the Crown versus Metron Construction Corporation. This case stemmed from the Christmas Eve 2009 scaffold collapse, which killed 4 construction workers and injured another at a high-rise construction site in Toronto. Now, the company was convicted of health and safety violations, including improper construction of scaffolding, not enough safety lines, and not providing instructions or other information for the workers involved. Now, the company was also charged and convicted with criminal negligence causing death in the case and was fined $200,000, and the president of the company was also personally fined $90,000 by the Ontario Court of Justice. Now, in September 2013, the Ontario Court of Appeal overturned the fine amount, finding there was greater culpability in the criminal offense, and the fine shouldn't be determined by health and safety ranges and the company's ability to pay. And the court raised this fine to $750,000. Now, also in the fall of 2013 was the case of Wilson versus Solis Mexican Foods. Now, in this case, the Ontario Superior Court of Justice awarded $20,000 to an employee for human rights damages as part of the employee's wrongful dismissal claim. Now, the case stemmed from an employee taking time off with back problems, and the employer rejected the proposed medical approval of a return to work plan, saying the employee should not come back until she was able to do her full-time duties. The employee was ultimately terminated, which allegedly was due to restructuring, but the court found the employee's back problem was a significant factor in her termination, and as a result, the employer was required to offer accommodation. Now, though this illness was not considered a disability, the court found a temporary illness was also protected under the Human Rights Code and shouldn't be a factor in termination. As noted, 2008 amendments to the Ontario Human Rights Code allowed human rights damages to be part of a civil action, although since then no such awards had previously been given. However, this was one of the first known cases of a court making a human rights award as opposed to just a tribunal.